Good morning. Happy Tuesday. I am firmly of the opinion that DMA has retained his attorney for the lawsuit against Frauditor Troll on a contingency and or attorney's fees theory of recovery. Probably a combination of the two. And if true, if my suspicions are true, so let's just say that let's just say that this attorney is putting in time and effort into this that he does not need to. I think this attorney is seeing this as not just an opportunity to recover for DMA and then thus for the attorney himself, but also as an advertisement sort of vehicle where he has some sort of an agreement with DMA. I'm assuming there's an agreement with DMA that he can use this lawsuit as promotional material for the attorney's brand, so that the attorney can attract more auditors and other people whose works are used by anti-auditors, etc., for further lawsuits, further recoveries. So my best underlying guess, based on my understanding of the case, my feeling for what the attorney is doing, he hasn't told me. I just want to be very clear. He has not stated his fee agreement with DMA to me at all, or even intimated. Are just things that I am drawing from what he's doing, from what people are saying about DMA's financial situation, etc. That my guess is he's doing this on contingency / prevailing party attorney's fees, or some combination thereof, which is not unreasonable. There are attorneys out there who all they do is send out copyright notices and try to get small recoveries. This is potentially a larger recovery, but the other thing is that attorneys don't tend to take these things unless there is a good probability of success, not just on getting the judgment, but on collecting. I've talked about this ad nauseum over and over again, all the way back to the very beginning of my channel. If you go to an attorney and you say, I want to sue so-and-so, they're going to give you one of three possible choices for how to proceed. They're either going to say, well, the choices for the attorney on what they offer. They can say, I'll do it on hourly, in which case what they're telling you is, if they insist on hourly, that they're saying, I don't believe either that you have a good case, that you're going to get the judgment, or I don't believe that we're going to be able to recover, i.e. that I'm not going to see a check coming in. So, for example, car accidents, attorneys will do those on contingency because there's going to be a insurer out there who will pay the personal injury fees. They're not going to duck service. I mean, it's just one of those things where you can get, assuming that you believe that you could prove that the other side's at fault, at least to a portion. It's almost guaranteed money. So attorneys are very likely to take those. But for example, a defamation lawsuit against a private individual, much harder, first of all, to prevail on, especially if it's a per quad, not a per se. And second of all, recovery is questionable. Does the person have money to pay the suit, to pay the judgment? So if the attorney's thinking that you're not going to recover, therefore I'm not going to recover, then the attorney's very unlikely to offer contingency, and he's going to offer just the fee agreement. On the other side is the contingency. If the attorney wants to go pure contingency, usually it's going to be for 1/3 to 1/2 of the recovery. That means the attorney's saying, look, I'm willing to gamble. So you don't pay any out of pocket costs, but at the end of the day, I'm going to get a bigger chunk. Hourly, you may only be like $50,000 in to an attorney by the time you go all the way through trial. Maybe. You could be more. But on contingency, that attorney might get $200,000-$300,000. If it's like if someone has $1 million policy, you could do pretty well sometimes. So, but the attorney has to be more or less guaranteed at some point that he's going to get a judgment, and B, be able to collect on the judgment. And that should tell you something. Again, this is something that I've said from the beginning. I almost guarantee, I am about 95% sure that this attorney has taken this on contingency and or prevailing party attorney's fees. That should indicate a strong likelihood that this attorney thinks he's going to get money. I just want to be very clear. Now, he could be wrong. He could lose. I don't know what he knows. He hasn't confided in me anything. But if things are the way I'm, like, I think I have a pretty good nose for this. A pretty good nose. It's just generally pretty big. I think I have a pretty good nose for this. And I just want everybody to keep that in mind. That's number one. Number two, the lucid lair thing. For those of you who missed it, she said, this is an illegal opinion. There's two kinds of opinions as far as I'm concerned. There's just your opinion. I think he's going to win. Well, you probably do think he's going to win. You wouldn't have said you think he's going to win if you didn't believe that. I have no way of knowing whether you're lying, whether you're being sarcastic, whether you're telling the truth. So I have no way to actually tell you that your opinion is wrong because that's your opinion. I like chocolate ice cream. Okay. Do I really like chocolate ice cream? You don't know, but you have no way of proving that I don't like chocolate ice cream, right? Now, you can have a different opinion. You could say, well, I like vanilla ice cream. Okay, great. I think he's going to lose. Well, okay, great. But there's nothing there. There's nothing informative there. There's nothing there other than in an opinion, in Lucid Lair's opinion, it's just her saying, this is my opinion. What am I going to disagree with? That's your opinion. Okay? That's your opinion. And the people go there to watch her, like her, because her opinion matches their opinion, so they feel validated. Congratulations. Like, all right. But then on the other side, there's a legal opinion. And legal opinions can be wrong. Legal opinions can be demonstrably, provably wrong. And if she was going to be making legal opinions, sure, I would have continued. But she said, I'm not making legal opinions. Congratulations. We're done. Right? When you're looking at a complaint, when the only thing you have is the complaint, all that you really are concerned with at that point is, will this survive a motion to dismiss for failure to state a claim? Will this survive a 12B6 motion? That's really, generally speaking, that's like, does it properly state jurisdiction? Sure, this one does. It says copyright. Congratulations. We've properly stated jurisdiction. It's proper in the federal district court. I don't know if it stated venue, but the venue is going to be appropriate because the agreement that when YouTube sends out these notices and these counterclaims, counter notices, there's an agreement that like, hey, like, bro, if like you're willing to sue in this particular venue, Northern District of California, the parties have agreed to it. So venue is appropriate. The next question is, does it state a claim like that if true, if all the facts alleged are true, do they recover? Yes, it says that. Okay, problem solved, done. That's the end of the analysis of a complaint. That's it. You don't know what affirmative defense is that, first of all, you don't know if Frauditor Troll is going to respond to it. That's one unknown. If he doesn't respond to it, well, then there's going to be a track that's going to be going down where he's going to get a default and presumably a default judgment. You don't know if Frauditor Troll responds to it, what his response is going to be, what affirmative defenses he's going to claim. You don't know anything. You don't know anything. Everything beyond what's in the four corners of that complaint is speculation. So, and unless you're a copyright attorney, unless you're an attorney who deals with these and you know about copyrights, like, your opinion is just your opinion, man. Which is why I'm not going in there swinging saying like, this is how it's going to shake out. I said this is how I want it to shake out, but I don't know. I don't know how it's going to shake out. And finally, another nail in the coffin of there's a distinction between the Frauditor Troll supporters and the Lane Meyer supporters is, I can't tell, but multiple people in the comments and in other forms of communications has said, you did exactly the same thing that Frauditor Troll is accused of being doing. Exactly the same thing. You used Lucid Lair's video? Yeah. Lane Myers supporters are like, oh, you're making videos about Lane Myers. Why isn't that harassment? You put a video up that had Lane Myers' contact information in it. The unredacted motion or opposition to a motion or something. I don't remember what it was. But it had, when he was pro se, it had his contact information. You did exactly the same thing. Exactly the same thing that Lane Myers did. What? You're harassing. You're infringing on copyright. Again, these are very stupid people who want bright line rules, who don't understand that you're not necessarily looking for only the similarities. You also have to look at the differences between what people are doing. For example, Frauditor Troll, most of his video was DMAs, allegedly, according to the complaint. And you only added a few minutes worth of commentary. And that commentary didn't add anything to it. Saying, no, isn't adding to it. You should back up. Oh, that's hard-hitting commentary and critique. No, I don't think it is. I think that's just nuh-uh, slightly rephrased. Whereas if you look at what I was doing with her video, I used 3 whole minutes of a 30-minute plus video. I used a tenth or less of her video. A tenth or less. There's a distinction. There's a difference. Out of my 22-minute live stream, 3 minutes were hers. That means for every 1 minute of her video, 6 minutes of mine. 1 minute of her talking, 6 minutes of me talking. And I used no more than what I needed to make the point. The point was she's not making any legal opinions. She's not offering a legal opinion. It's a waste of fucking time. Once I had resolved that issue, done. Didn't use a single second more of her video than I needed to make my point. The differences are more important than the similarities. Some superficial, trivial similarities does not mean that it is harassment. Does not mean that it is copyright infringement. And that's why Frauditor Troll supporters are a cunt hair difference from Lane Myers supporters. And both of them hate me because I'm not even involved in the lawsuit or the criminal case, but I'm saying things they don't like, and so I'm the bad guy. Whatever, dude. Whatever. Like, for people who want the truth, for people who want an unbiased opinion, you can come to me, and you may like what I have to say. Great. Doesn't matter to me. I'll probably say something that'll piss you off in the future. Or you may hate what I say. Congratulations. Like, I don't fucking care about your opinion anyway. I'm not going to your channel for your opinion. I don't really care about yours. I'm going to tell you from an educated standpoint, not Lucid Lair's, I have opinions. I have an animated owl on my screen. I have allegedly a criminal record. Buy me a coffee. Fucking people are retarded. Like, people are legitimately retarded. Like, why do people get so fucking invested in either side? Why do you fucking care about Lane Myers' case? Why do you fucking care about Frauditor Troll? You have nothing better going on in your life? Like, I mean, I get it. It's entertaining. Sure. Watch videos on it to be entertained. Sure. But to get so invested that you get upset with someone for telling you, like, it's a good complaint. My actual critique of the complaint was, it's a good complaint. It's a workmanlike complaint. It's not amazing. It's not bad. It'll survive a 12B6, at least as I see it. It'll survive a motion to dismiss based on just the complaint itself. In California, we'd call it a demurrer. It'll survive. There you go. And all of a sudden, I'm the bad guy. I don't like Frauditor Troll. I think he's a piece of shit. Oh, all of a sudden, I'm the bad guy because I have an opinion about Frauditor Troll. Okay? Everybody's got a white knight to save him. Congratulations. You guys are fucking faggots. Have a great day.